Gangs are notorious for bringing fear to the streets, but inside the courtroom, their coldness is even more chilling. Some smirked, some mocked, and others stared down families without a shred of regret. Then came the case that erupted into a shocking attack caught on camera. These are the cold-blooded gang members who had no remorse in court. A federal racketeering case was moving through trial in Salt Lake City. The charges tied Seal Angelau to the Tongan Crip. Prosecutors said the gang used fear, guns, and violence to control drug corners and settle scores. Witnesses were members and rivals. They were called in to describe the rules of the set, hand signs, threats, and past attacks. Jurors listened while agents mapped out crews and names on simple charts. On April 21st, 2014, the courtroom filled early for a trial day that began like any other. Jurors filed in. The court swore in a witness. Everyone settled. Angelau sat at the defense table with his lawyers. The judge reminded the room of the rules. No talk unless asked. No sudden moves. All questions go through the court. It was a normal start to a high-risk day. Then, a small thing changed the air. A witness used a name that hit a nerve. The words were plain, but Angelau's posture shifted. He pushed his chair back, rose, and moved fast. In one motion, he broke from the table, grabbed a pen, and charged the witness stand. The distance was short. The intent was clear. He aimed the pen like a blade and closed the gap in seconds. The room exploded into movement. A deputy marshal between the tables shouted and drew. Another marshal pivoted from the rail. The witness tried to duck. Jurors recoiled and pulled at their seat arms. One marshal fired to stop the attack. The shot echoed and paper floated down from the stand. The pen clattered on wood. The entire sequence took a blink and a half. The judge ordered the room cleared. Everyone out. The clerk moved the jurors through a side door. The witness was pulled behind the stand. Marshals spread out to hold the space. The judge checked on the staff, then on the witness, then on the jury. He asked for a medical team and for a full note on the record. The bailiff locked the doors. The hallway was filled with noise and camera crews. Inside, the judge spoke in a low voice to keep the transcript clean. He marked time. He listed who was present. He explained why force had been used and what would happen next. When the court reconvened, the judge set a firm tone. The order would be kept. Security would be tighter. No one would approach a witness without permission. He spoke to the jury about what they had seen. He told them their safety came first. He reminded them of their duty to decide facts only on evidence. He then recessed again so jurors could talk with staff and get support if they needed it. By the next session, procedures had changed. Extra marshals stood near the witness box. Counsel tables were moved slightly. Pens and other items on the top rail were reduced to the bare minimum. Defendants were seated with more space between them and the aisle. The court made sure every person who spoke from the stand had a clear lane to exit if trouble came again. There was no sentencing. The trial could not go forward. The case ended in shock and grief. Afterward came lawsuits, depositions, and a public fight over whether the shooting was justified. In March 2018, a federal judge ordered the release of the courtroom video so the public could see what happened in real time. Policy reviews followed. Training for marshals stressed how fast a person can cover ground inside a small room. Judges in other districts adjusted floor plans for high-risk gang trials. Some added more screening for objects on counsel tables when a cooperating witness took the stand. Others rehearsed evacuation paths so a jury could be moved in seconds. The debate did not fade. Some said open courts must show the truth, even when it is dangerous. Others said safety must come first and that cameras and open benches invite chaos when gangs are involved. Court leaders tried to hold both ideas at once. They kept doors open, but with more eyes in the room and clearer rules about movement. The message on the record was simple. No attack will be allowed to change a verdict or silence a witness. This was sudden violence with no words. The next case is all words and faces, no attack, no sprint. Just 5 quiet defendants who walk in calm and leave the room colder. Next up, Rashad Murphy, Shaw Gathright, Isaiah Chance, Alicia Andrews, and Davian Murphy. Julio Fulio, case defendants. Police linked 5 people to the June 23, 2024 ambush killing of Jacksonville rapper Julio Fulio in Tampa. The work started with cameras, phone records, and travel logs. Detectives pulled data from towers, looked at cars in the area, and built a map of who moved where. Each arrest happened in a different place, but the picture pointed to the same crew. Prosecutors say the plan was careful. Phones were swapped, rides were layered, a hotel, a parking lot, then a quick strike. The warrants list messages. license plates, and a trail of calls before and after the shooting. Defense teams push back. They say the web of pings and clips proves movement, not intent. They ask how many people passed through those lots that same night. They ask what was in each person's head, not just in a phone. First appearances came fast in late July 2024 after Tampa police announced arrests on July 29th. Separate courtrooms, same rules. Confirm names, read charges, set bond. No contact with each other or with witnesses. Do not post about the case. Do not send messages through friends. The judge looked from face to face and asked each person if they understood. Each said yes. The gallery was full of family and press. The five said little. No speeches, no outbursts. One looked at the floor. One glanced at the cameras. Another kept a half smile that did not reach the eyes. The lawyers did most of the talking. They asked for bond numbers that their clients could reach. They pointed to jobs, kids, and roots in the city. The prosecutor stood and said the risk was high. He spoke about phones that go dark, plates that get swapped, and witnesses who feel watched. The judge took a slow tone. He reminded everyone that first impressions are not a trial. He read the possible penalties. He went count by count. For one defendant, no bond. For another, a high bond with strict rules. For the rest, bond decisions set with tracking, curfew, and no contact. The clerk read the orders again. Deputies nodded and wrote down the terms. In a later bond hearing, lawyers fought over the phones. The defense said the data was thin and the links were weak. The state said the phones moved together like chess pieces and that the path of the cars matched the phones. The judge kept the bond as set and warned both sides about gag orders and leaks. He said the case will be tried in court, not on a phone screen. There is no sentence yet. Pretrial moves now decide who stays in jail, who goes home with a monitor, and what evidence will come in. Motions target the phones, the cars, and the way the warrants were written. The families come back for each hearing and sit on opposite sides. The air is tight. No one speaks to the other row. Reporters write down every small detail and pass it to the world. Online, people argue and pick sides. In court, the faces stay still. The quiet feels hostile because it never cracks. The judge keeps the room steady. He repeats the same lines at each hearing. Do not reach out. Do not hint. Do not act tough on video, and do not test the rules. The next time any of them speaks at length, it will be under oath. Silence can feel like a threat. Those five barely moved, yet the room froze. Now step into a case that talks back. Caius Vaiovis meets the verdict with a stare and a final line that stings. 3 men were taken, beaten, and killed in western Massachusetts. The case moved through months of groundwork. Detectives searched back roads, creek beds, and storage spaces. They followed tips into biker hangouts and across state lines. When arrests came, the press used short words for what they found: kidnapping and execution. Caius Vaiovis was tried apart from his co-defendants. He kept his look sharp for every sitting. Shaved head, sharp lines shaved into the scalp, symbols cut into the skin. He said nothing about deals. He wanted a trial, not talks. The state built a motive around loyalty and orders. They leaned on phone records, cars seen near a house, and the recovery of remains. They called witnesses who talked about fear and rank. The defense said the links were thin and built on guilt by the crew, not proof by act. Jurors saw photos that no one wanted to see. They heard about the last hours of the victims. They listened to experts on marks, timelines, and the way body recovery works when the ground is wet and days have passed. Each piece was small. Together, it was enough. On September 26, 2014, the jury found him guilty of all 3 murders. Through the verdicts, Vaiovis barely moved. He watched the 4-person speak. He looked at the judge. He looked at the gallery. The families of the victims sat in tight rows. Hands were held, eyes closed. One man stared straight at the defense table and did not blink. When the judge thanked the jury, the room was still. At sentencing, the court let the families talk. They described small, ordinary things they missed. A morning coffee that never happens now. A singed recipe card in a kitchen drawer that still smells like their loved one. Words that are simple and feel heavier than any speech. The judge listened and nodded. Then he turned to the defense table and began to read. Vaiovis waited for his turn to speak. When the judge finished, he stared back. He told the room they would see him in hell. A few gasps, a few curses were swallowed and turned into tears. The judge did not react. He told the deputy to remain ready and then return to the record. On September 29, 2014, the judge imposed 3 consecutive life terms without parole. The judge explained why the terms would stack: 3 lives taken, 3 life sentences. The defense filed notices of appeal. The appeals failed. The quote lived on in headlines, but the time is what mattered. Vejovis will die in prison. Law schools and judge trainings use the case to talk about demeanor. How can a defendant say nothing for days and then choose one line to define a whole trial? How a judge keeps control when a courtroom looks to him for a reaction. In this room, the judge never raised his voice. He gave the years and closed the file. From a showy glare to a schoolyard scene. No speech, no drama, just a sudden knife in a crowd and 2 young faces set like stone. Continue with Anthony Carpio and Michael Stephen Carpio. On April 24, 2013, a Cleveland high school student was fatally stabbed during a hallway confrontation. The day felt normal until a sudden rush of bodies and shouts. Within seconds, a knife flashed. Kevin fell. The fight was not a fight at all. It was a quick hit that left one teen on the ground and everyone else running. Detectives pulled footage from cameras on campus and nearby streets. They spoke to students who saw faces and clothing. A few told the same story in short, careful words. They had seen the Carpio brothers around. They had seen hand signs and small threats that built up in hallways. Some kids tried not to look at the photo boards. Others pointed and stared at the floor. Piece by piece, names lined up with images, timestamps, and bus routes. Prosecutors filed murder charges with a gang enhancement. They said the brothers were part of Rockwood and acted together. They showed maps of who stood where and how fast the group moved. They brought in a gang expert to explain how a school hallway can be used to show dominance and fear. The defense said the scene was chaos. They said the crowd was big and fast, that memory can change, and that a teenager's mind under stress is easy to push. The brothers sat side by side at the defense table. They spoke only to answer the judge. Their faces stayed flat. No tears, no words to the gallery. Kevin's family filled the first rows. A mother kept a small photo in both hands. A classmate came to the stand and could barely lift their eyes. A teacher described loud noises and then a quiet that did not feel normal, a quiet that comes after harm. The judge told the room that a school is supposed to be the safest place a child visits 5 days a week. He talked about packs and pressure, about the need to prove yourself when older boys watch. He said everyone who wears a backpack deserves to get home. He reminded the courtroom that small choices add up quickly when a knife is in a hand. The gallery listened in silence, broken only by short sobs. On January 15, 2015, the court imposed 16 years to life for Anthony and 15 years to life for Michael. The judge said the terms reflect a young age and also a deadly act. He asked the clerk to set dates for future reviews that the law requires, then looked at the family and thanked them for speaking. After the case, the school district added more eyes in the halls and near exits. Campus officers adjusted passing period patrols. Trainers spoke to staff about spotting pre-incident signs, like silent groups forming and sudden shifts in walking patterns. Community teams ran talks with parents on phones, rival crews, and how a small slight online can lead to a real blade in a real hallway. In youth centers near the school, mentors started evening sessions to pull teens away from crews that sell protection as belonging. The file became a warning, used in assemblies. Counselors held small circles where students could say what makes them feel unsafe. No drama, no speeches, only names, places, and times that adults needed to hear. The message was simple. A hallway is not a hunting ground. A school corridor, young faces, and a knife that ended a life. Now shift to a quiet house and an elderly woman alone. No crowd, no chant, only a door forced open and a smile that chilled the courtroom. On April 14th, 2010, 81-year-old Dorothy Session was attacked and killed inside her home. Someone broke in at night. Rooms were pulled apart. She was beaten to death in the search for quick money. The scene told most of the story. Drawers on the floor, footprints on tile, blood where it should never be. Detectives followed simple clues. A shoe pattern matched a pair found later. A cut on a hand matched blood on a window frame. Stolen items turned up at a shop that keeps a log. The clerk remembered a face and a jacket. Cameras at a corner store caught a man with those same items an hour after the break-in. The timeline set itself. The arrest came soon after, and the name was David Moses. Prosecutors walked the jury through each step. Entry point, injury list, items taken. They said the motive was money and the plan was simple. Break in, grab what you can, leave fast. The defense said the case relied on parts, not a whole. They said the items could pass from hand to hand, that a cut could come from a fight somewhere else. At hearings and sentencing, Dorothy's family sat close together. They told the judge about a woman who kept extra cookies for visiting kids and ironed pillowcases because it made guests feel welcome. As one niece spoke, Moses yawned. He smiled. At one point, he laughed. The gallery gasped. The prosecutor stopped mid-sentence and looked to the bench. The judge ordered the room to hold steady and noted the behavior in the record. He told Moses that this is a place for truth and respect, not a stage for mockery. Family members finished their statements in quiet voices. One held a sweater Dorothy had knit. Another said she still sets out a mug when she makes tea for two, then puts it away again. The words were small and sharp. The room felt the weight of them while the defendant stared ahead. He was sentenced in 2012, and on October 21, 2020, he was resentenced to life without parole. The judge said the crime showed a level of cruelty, and the courtroom behavior showed no remorse at all. Deputies led Moses out. The family stayed seated for a moment and breathed. The case moved into training for victim advocates. It became a guide for how to support families who must speak while a defendant taunts them with a smile or a yawn. Police departments used it to show new officers how to work a burglary that turns into a homicide and how to tie together footprints, pawn tickets, and timestamps without losing the human story. In neighborhood meetings, people were urged to check on elders, install simple lights, and help with door locks that stick. Small steps that matter when someone decides to prowl. Clips from the hearings circulated online because of the grin, but in the courthouse, the only thing that counted was the term, read aloud, a life sentence, a door closed. One man mocked a grieving family and walked into life in prison. Next, two brothers face federal time and respond with smiles and waves. Less blood in the charges, same cold message in their eyes. A long federal probe pulled in calls, texts, and street buys tied to the 1200 out east set in Jacksonville. Agents logged controlled purchases, tracked guns moving through cars and apartments, and mapped out who moved the product and who guarded the stash. Names surfaced over and over. Rashad Johnson, Marquez Johnson, brothers in the same circle. Wiretaps caught talk about drops, lookouts, and late runs. Undercover buys lined up with those calls. Search warrants turned up cash, scales, loaded magazines, and lists that read like a small ledger. Co-defendants began to cut deals. They handed over phones and took the stand to lower their own time. The case against the brothers did not shrink. It grew page by page. At trial, prosecutors built the pipeline in simple steps. Buy here, text there. Car door opens, hand to hand. The defense said the tapes were chopped up and the cooperators were liars with a reason to talk. The jury listened to days of audio and watched clips that matched the words to places and faces. The verdicts followed. Sentencing came next. On sentencing day, the brothers walked in together. They scanned the gallery and found their people. Both men smiled. One lifted a hand in a small wave. Cameras clicked softly. The judge told them to stop and face forward. They kept calm and kept the grin. Victims of the drug trade spoke. A mother said her son lost 2 years to a habit that started at a bus stop. A store owner said he closes early now because the block feels wrong after dark. A pastor talked about funerals for boys who never turned 21. Their words were short and cut through the room. The prosecutor said the case was not about one night, it was years. It was a line of buyers that never stopped. Defense counsel asked for mercy and pointed to childhood, family ties, and the chance to change with time. The brothers stood with shoulders square and eyes steady on the judge. On September 6, 2023, the judge imposed 30-year federal sentences on each brother. Supervised release to follow. No reaction from the bench, no sound from the defense table. Beyond a slow breath, the brothers nodded once, then looked back at the gallery, another small smile. Deputies stepped in and turned them toward the side door. The clip of those last looks spread online. It became a symbol of bravado that costs decades. In the city, community groups used the case to push for re-entry programs, trade schools, and paid apprenticeships that start before the pull of a set takes hold. Youth coaches talked about keeping teens busy until the late bus, when the trouble usually starts. The paperwork in court was measured in pages. The cost outside was measured in blocks. Grins after 3 decades is one type of cold. The next is silence from a shooter who took a kid with a future. No waving here. Only a long stare and a number that ends the best years. Amir Griffin was 14. He played basketball near a park in Queens and talked about high school hoops. A feud between crews had been simmering. On October 26, 2019, the shots came near the Baisley Park Houses basketball courts in South Jamaica. Neighbors called in what they heard and what they saw. Cameras picked up a figure moving fast, then a flash. Detectives pulled footage from blocks around the park and matched it to license plates and phones, pinging off nearby towers. Street tips brought a name that fit the path on video. Ballistics tied the shell casings to a gun later recovered in a different stop. The file grew into a simple chain: walk, aim, fire, run. The arrest brought a slow ride to court. The name on the file was Sean Brown. Prosecutors said he was the shooter in a fight that was not a fight at all. There was a boy with a ball and a person with a gun. The defense pushed back on ID and angles and asked about the gaps between frames. The judge set trial dates and kept the rules tight. In court, Brown stood still with his head down. He answered the judge in short words. No apology, no eye contact with the family. When it was time for impact statements, Amir's mother held a jersey in both hands. She talked about sneakers by the door and a laugh that still fills the apartment at night. A coach said Amir ran drills after practice just to get one more shot to feel right. The gallery was quiet, except for the sound of someone crying into a sleeve. The prosecutor spoke about the park and the arc of the bullets. The defense said the state was stacking inferences. The judge kept a steady tone and reminded the room to hold on to the rules. No talking from the seats, no looks across the aisle. He asked the families to breathe, then moved to the term. On April 10, 2024, the judge sentenced Brown to 30 years in prison, including post-release supervision. The judge said the number would not bring back a child, but it would mark the harm. Brown looked at the floor and did not speak. Deputies led him to the side door. The family held each other and stayed seated until the room was nearly empty. After the case, the park hosted a memorial game in Amir's name. A youth league put his number on every ball for a season. A school gym hung a banner that reads, "Play hard, be kind, Amir." On the streets around the park, violence interrupters stepped up night patrols. They talked to kids still in middle school about beef, rumors, and the way a text can pull you to the wrong corner at the wrong time. The case became a rallying point against neighborhood feuds that swallow kids who should be filling out team sheets, not face sheets. Coaches, pastors, and parents met in the school cafeteria and set up carpools so teens were not walking home alone after late practices. The gym lights stayed on a little longer because sometimes one more hour on a court is the same thing as one less minute on a corner. Cold faces, colder choices. These courtrooms showed more than charges and years. They showed the price of crews that value status over life. Some tried to scare, some mocked, others stared like stone, all left with time that will not fade.